Vano, I'm
Yes.
very grateful that you agreed to give an interview. And as I understood, Ayjan Baltabek is not working with you anymore. And many people concluded contracts with your company because of her, because we know her,
Yes.
and she explains legal issues very well. And now I would like to know about you from professional side.
Sure.
Could you please tell me about yourself, your background, your experience, and
Sure.
how long have you been working as immigration lawyer?
Sure. Okay. Well, thank you. And you are correct. So about 2 weeks ago, my firm decided to end our relationship with Ayjan. So we are right now not working together, so to speak. However, during the time while we were working together, we had a lot of clients who came to our firm and signed up with our firm through her. She was a new attorney in immigration, and I felt that she understood very well immigration law, and had clientele, mostly people who, like her, were from Kazakhstan, but not all. I mean, mostly we had clients from, I would say, all over the world who came in through her, and we had many clients that were that signed up with us in order to try to get their immigration status, basically, to use common term, to get a green card. And as far as myself, all right, so I have been an attorney. I'm an attorney. I'm licensed to practice law in New York and in New Jersey. And in a couple of months, it's going to be my 20-year anniversary as an attorney. I was admitted as an attorney in the courts of New Jersey in December of 2002. So it'll be 20 years. And it's been a couple of years less than that in New York. And also, I have been practicing in the federal courts for the same amount of time. Federal courts include, of course, immigration courts, and I have been practicing in most of the immigration courts in the country, from the East Coast, West Coast, Puerto Rico, and with a lot of clients in New York, New Jersey, Pennsylvania. But really, it's a nationwide practice. So my experience in immigration law has been pretty much from the beginning. And although I was a federal court litigator, something more like a trial lawyer, during a lot of the years, I have always practiced immigration law from the first year that I was an attorney. And from the first year that I came into this firm, Ball & Stoll, about 17 years ago, we had a partner here who was an experienced immigration attorney. He's an older gentleman who's still with our firm, and he still provides some consulting and all that to us as a partner of the firm about immigration law. So I learned initially from him, but then later on, with the experience of me. So I've been practicing immigration law in New York and New Jersey and throughout the United States for the better part of the last 20 years.
What is your company specialized in? Who is the significant clients?
Well, we have a lot of, my company it's what we call a medium-sized law firm. We have right now, I believe it's 22 attorneys who work at the firm, and we have 14 paralegals. So we have different areas, so you're asking me what area do we concentrate in. So we have an office in the West Coast. We have an office with a partner in Nevada. So most of that practice is tax and corporate law with a lot of estate law. So it's more transactional work. We also have a partner who's right next door to me, Marshall Bellivan. He's a very experienced litigation attorney. He's the head of our litigation. So when I say litigation, I'm talking about employment law, I'm talking about commercial disputes between companies and all that. So that's another area we have. And our immigration area is one that has been growing a lot over the last few years. It started out as a service to our international clients, and because of my background, I have a lot of international clients. So we started out trying to do immigration for them. They wanted their key employees, their family members to come here to get a green card. So we started doing E-visas, L visas, EB-2, EB-3, EB-1, EB-4, EB-5 for those clients. So that's how it started. And then eventually we started getting more and more what we would call consumer clients, clients who were actually trying to get a green card for themselves, not necessarily through a company.
Regarding EB-3 visas,
Sure.
they have skilled and unskilled employees, correct?
Correct.
How much percentage of approval do you have from skilled and unskilled category in the last 2 years?
Okay, so EB-3, also known as PERM, P-E-R-M, it's one of the harder immigration strategies. So the way that works is generally it is meant for employers, for companies in the United States who are looking for employees and want to get those employees a green card so that they can come and work for them. And as you correctly stated, there's skilled and unskilled categories. Traditionally we did more of the skilled labor. Our clients were generally medium-sized companies who were clients of the firm. And they would come to us and they would tell us, you know, they're looking for employees in different areas. So what happened is during the pandemic, right after the pandemic, when everything started reopening, if you remember, there was a very serious shortage of labor, which still is in place. So we're talking about the summer of 2020. So at that time, I started getting more and more clients asking me, hey, Vano, do you have, you know, we have hotels in Florida, we have companies in Michigan, we have New York, New Jersey, different businesses, different, no connection one with the other, telling me that they were looking for employees. So at that time, you know, we started actually, you know, introducing our employer clients to the employee clients. I mean, introducing is probably not the right term, but it was more like a recruitment for those clients who wanted to get employees to come and work for them. So because of my background personally in the firm, because of the firm's background, we have literally tens of thousands of clients. And most of those clients are small and medium-sized businesses. Some of them are bigger businesses. We have some bigger businesses, but our typical client is a business that does anywhere from $2 to $20 million in sales a year. So not huge corporations, but regular-sized companies. So that was a good source of you know, a network that I had of clients who had that. And at the time, the need arose for those clients to get employees, and the opportunity was right, and we were able to basically, you know, find a lot of clients who were perfect, or at the very least, very good candidates for those companies at a time where it was very difficult for them to find employees to come work for them.
What you can say about EB-2 visa?
Sure. Okay, EB-2 is a very interesting visa. EB-2 in general is got different categories. When I say EB-2, I'm referring to EB-2 NIW, National Interest Waiver. And this is very important. The waiver part means it's a waiver of a labor certification. So it's a little bit, you don't need labor certification. So it's a little bit like EB-3, except that you don't need labor certification. As a result, you don't need an employer. So if you're an employee and you are a person in the United States or even overseas, you don't have to be in the United States, and you have the specific skills that are required for the national interest, then you are entitled to get directly a green card. And when I say directly, is no employer needed, it's self-petitioning, and it's a very quick process. Again, everything is relative in immigration. You know, there's been a lot of delays over the last couple of years, but the average processing time right now for an EB-2 is between a year to a year and a half, although we've had some that were much quicker than that. So EB-2s traditionally were a little bit harder to get approvals on because, again, you have to show that it's in a national interest, and until recently, although unemployment had been low for some years, there was no real labor shortage. However, what happened is after the pandemic, we started having a severe labor shortage, which meant that a lot of the industries, a lot of the areas needed qualified employees. Under the EB-2 NIW system, you need to have either a master's degree in order to qualify for it, or if you have less than that, for example, if you have a bachelor's degree, you need to have a certain amount of experience. You can also have it without a bachelor's degree, but then you need a lot of experience, you need skills, and you need to show that the person is exceptional. Very important, exceptional is not extraordinary. Everybody knows the talent green card, EB-1. EB-1, you have to be extraordinary. EB-2, you have to be exceptional. Exceptional is a much lower standard, it's much easier to meet, and you know, my experience has been a lot of the immigrants are truly exceptional. Their background, their education, they either have master's degrees or they have bachelor's degrees with a lot of experience, and therefore they're exceptional. And the fact that we are in the middle of such a strong labor shortage makes it that it's much easier now to qualify for an EB-2 NIW green card petition than it was, for example, 3 or 4 years ago.
Who was a like IT specialist or what kind of?
So traditionally, the shortages were in IT. Traditionally, shortages were in some finance areas. In the last year, there is almost nothing that doesn't have a shortage. For example, teachers. Teachers were not a fast-growing area. Now, there's a severe shortage of teachers. So if somebody has a master's in education and pedagogical science, whereas 3 or 4 years ago I would have said, you know, it's going to be hard to show that it's a national interest. Today I will say it'll be very easy to show because there is a huge need for that. Everything having to do with finance areas, everything having to do with you know, management, with companies. There's a shortage for all types of labor. So that means that almost all of these people who are educated and trained in those fields will be in the national interest. And you asked me before, us as a firm, the numbers have shown it. We've filed a couple of hundred applications of EB-2s in the last 2 years, and so far, you know, again, this is a process, and every application is different, so you can't take it as a trend or anything like that. However, so far we have been able to have most of our applications either approved or at an RFE stage, you know, going towards approval. So, you know, there's been a very high rate of acceptance of the applications. Of course, we are very careful with how we select the ones that we apply for EB-2. We want to make sure that they are qualified, and we're also very careful about how we present it. We have specialized writers who we could take what the qualifications a client has and emphasize it and present it in the best possible way in order to, you know, maximize the chances of the people applying for it.
So after approval of petition I-140 from UCIS on EB-3 visa, what are the further steps?
Okay, once it's approved, right? So you're approved for a green card. However, it doesn't stop there. You know, again, the I-140 is approved, the I-485 has to be approved. 485 is basically what's called an adjustment of status. So they're only interested in seeing that the I-140 is approved. So if the I-140 is approved, I-485 theoretically should be approved without a problem. However, they look at things like background, they look at things like just to make sure that there's no fraud, that there was nothing like that. But background is the most important. You know, they want to make sure that the person is not a national danger. They want to make sure that the person doesn't have a criminal background. They want to make sure that's the kind of thing that they look for. Until about a year ago, every single application that was approved resulted in an interview. About a year ago, they changed the guidance, the regulations, and it went back to the way it used to be in the past, which is that almost always there are no interviews. They look at the record, they look at the papers, and usually the last step is they ask for a medical certificate. You know, there's a couple of medical things that you have to check also and pass. And after that, they mail us the green card. And then we tell the clients, hey, you know, we got your green card, and we send it to them.
How long it takes, like?
After approval?
Yeah.
It's been, our experience has been about 3 to 4 months. Yeah.
Okay. Is it possible to get a green card with an EB-2 visa now?
Yes. Again, EB-2 or EB-3 or EB-1 or EB-4 or EB-5, all of them have the same end result, which is a green card. It's all of them are called for filing an I-140, and an approved I-140 is an approved green card petition. Again, I'm using the colloquial. It's a permanent residence here, but it's basically the green card. So yes, an EB-2, just like the EB-3, once it's approved, it's a green card. It's the same green card that you would get in EB-3. It's not different. It's not a conditional green card. It's a permanent residence. It's a 10-year green card that is also can be renewed after the 10 years.
Okay. I would like to ask about like communication.
Sure.
Because before, when we work with Aya, we usually like make an appointment by phone calls, 10, 15 minutes.
Right.
So now your future client, not like future, I mean, clients, how will communicate with you?
Okay. So this is kind of a newly developing area. So you know, so we're kind of putting in protocols in place as we go on, because you know, we're talking a big number of clients who have all of a sudden, you know, gotten in touch with me and said, hey, look, you know, Ayna told us that she's no longer working with you, but you are our lawyer, so we'd like to communicate with you. So, so the last couple of weeks have been, have been very busy as a result. I've had, over 100 clients, contacting me at the same time, and we have a staff, but I thought it was very important, at least initially, that I myself be communicating with those clients and talking to them, agreeing what has been done, what needs to get done, and what is the likelihood of everything happening. So I've been working with the clients mostly by email and by text message. So my general, so before this happened 2-3 weeks ago, generally, generally I have very capable legal assistants, paralegals, and they communicate directly with the clients. However, every single client, I've always told every single client, look, you have my cell number, you have my email address. I don't answer cell calls because most of the time I'm in meetings and everything like that. However, I do answer text messages from all clients. I try to answer them on the same day or within 24 hours, and almost always that is the case. And so that's how it's been. But what I've done is I've scheduled Zoom calls, because most clients are throughout the country, they're not in the area. I have some clients who are coming to the office, but mostly through Zoom. I've met with clients and kind of decided how we are going forward. But to answer your question, every client can text me, can email me, they will get an answer from me. Over the last couple of weeks, there might have been a couple who I wasn't able to respond to immediately just because of the overwhelming numbers, but that won't be the case going forward. And there will be paralegals, there will be other paralegals, sometimes the same paralegals, who will be assigned to them, and those paralegals hopefully will be responding, more quickly. We do have a rule to respond to clients, communications within 24 hours, no matter what it is.
Okay, thank you.
Sure.
So if a person applied for an EB-3 visa and received work authorization, so the person is on the student status, should he keep the student status or can he stop studying?
The answer is he should not keep and he should stop it. So if he needs to go to school and finish the school, they could do that, of course. But they don't need to keep it, because once you have filed an I-140, your status, you are quote unquote adjusting your status. Okay, so if you were under an F1 visa status and you sent an I-140, you will get a receipt. Usually within a few days you get a receipt that says, you filed for the I-140. Your status is pending I-140. And you will get work authorization, you will get travel authorization. But even before you get the work authorization, your status is under the Y-140. You don't need to keep your immigration status with other things like F1 or B1, B2.
What if it will be, if his case will be denied?
Denied. Okay, that's a question that clients often ask. There is no solid law on this, but there is solid practice for the last 100 years, whatever, the way it works. So technically, when you are applying, you are pending, right? So you're pending. You did an I-140. So you came here, you have an F1 visa, and you are here under a student status. You applied for an EB-2 or EB-3, EB-3 after labor certification, and now you are under I-140 status. So you're in good status, there's no problem. If it gets denied, you have 33 days to appeal or reconsider. So while it's in appeal, and there are many levels of appeal, while it's in appeal, you are still in status, you still get to keep your work authorization, you can renew your work authorization, you can renew your travel authorization. So this is a multi-year, story here, and you are still in compliance. Technically, one other thing I want to add. Don't forget, you could always also file another thing. For example, you're waiting for your EB-3. You can apply for EB-2. You can apply for EB-1. You can apply for EB-4. You can apply for EB-5. You can apply for other things. There is no restriction under our immigration rules as to how many petitions you have. You are legally entitled to apply for whatever petition that you qualify for. So certainly somebody could do that. They can also apply another thing. Ultimately, if it's denied and not appealed, you are supposed to leave the country within 30 days. This last part, there's no real regulation on it. That's just the practice the way it is. So that if you are here for many years and you did an I-140, it got denied, you didn't appeal it, you left. So when you come back later and they ask you at the border, they say, hey, how come you stayed here for 2 years? You could say, look, I had a pending I-140, and when it got denied, I went back within 30 days of that. So ultimately, yes, when it's denied, it goes back and you don't have the status, but you're still not out of status. During the whole time you were in status, and as long as, if you're not going to appeal it, you leave the country within a certain amount of days, then you haven't, like, stayed here out of status.
So if EB-3 will be denied, but the applicant received like work authorization,
Right.
is it possible that USCIS can revoke it?
USCIS does not revoke it. What is possible, there's two things if it's denied. If it's denied, you could either appeal it, which it remains in effect, the work authorization, it can be renewed, or you could ask for the I-140 to be transferred to another application, EB-2 for example. Yeah, you could do that. So, and then it will be valid also. However, if you don't appeal, if you don't do another I-140 and it's denied, you cannot renew it certainly. Now, again, there's no real strong law on this. I couldn't find, and I don't believe there's like actual law on this. Probably technically, if you're not going to appeal it, your work authorization is, would technically not be enforced. However, there's no people travel and people work. There's, I mean, I've seen people use the travel parole. They came back after it was denied and all that. As long as the date is valid on it, the government will honor it. Of course, it cannot be renewed if you don't appeal it or if you don't do something else. So when it expires, then it expires.
You also told me before that, for example, a lot of clients was applied like for EB-3 visa,
Right.
and also you said like as backup, you can apply for EB-2 visa.
Okay.
Now you said that you have a lot of cases that EB-2 is much better, and that you can apply only for EB-2 visa, correct?
Okay, that's generally correct what you are saying. So EB-3 nationally has a denial rate of about 35%. Okay, so and we are talking nationally. You are talking about people applying to Facebook and Google and all that, and employees. So we're talking about big law firms with big clients and all that. They can get the EB-3 is you can Google it and you can read about it. It's a difficult process. It's very hyper technical. There's a lot of the little details, and any one of those, if there's anything that doesn't work and doesn't match, and there's any kind of conflict in any way, it can get denied. So EB-3 is by no means, I mean, nothing is guaranteed in immigration. None of the petitions are guaranteed, but EB-3 is particularly difficult. So there is always the likelihood of the application not getting approved, and anybody who says otherwise is not being forthcoming. So that's always should be clear. EB-2 traditionally, as I discussed before, was difficult to get approval for because again there was no labor shortage and things were a little bit harder. What we have experienced, as I told you, in the last year is that it has been approved at a higher rate than it used to get approved. Again, due mainly to the fact that there's a labor shortage right now, and it's you could meritoriously represent to the government, to immigration, that there is a need for that person who's in this particular industry.
Okay.
Yeah.
So Vano, thank you so much for your time.